Everybody say, ah. Say, oh, oh. Say, how can I express my gratitude for all the many things you've done for me? Words are not enough, to say thank you. Say, Lord, you are my everything. You're my everything. How can I express my gratitude? How can I express my gratitude for all the many things, you've Father, you done for me, yeah. Words are not enough to say thank you. So Lord, you are, you're my everything. Say, I call you God. Lord, my provider. I call you Nisi. You are my battle.
Hello, lovely people. It's good, it's bad, it's worse, it's better. And when I say these things, I know you would want to put your mind to what I'm going to talk about. I'm going to talk about that holy and very wonderful union that a man and a woman come together to have, or two families with their representatives as people go into marriage will have. Now, today I'm going to look at for better or worse, but not my property. What happens when something like that happens to you and somebody says that? Yes, I love you for the good and better. In bad situations, I'll still love you, but not my assets, not the property I have acquired. I know it tickles your fancy. You want to imagine what I'm talking about. So I want to invite you to once again this very wonderful Saturday afternoon in July to join me on the program, The Community and the Law. My name is Owusu Frimpong. Welcome to the program. It's a wet Saturday afternoon here in London, live on BWTV. We're bringing you The Community and the Law. Another wonderful Saturday is here with us. And by courtesy of BWF Solicitors, we are coming your way with a wonderful discussion that brings you everything you need to know about the law, especially your stay and your position with the law here in the UK and all over the world. My name, once again, is Owusu Frimpong, and I am the host of this program, The Community and the Law. Now, this afternoon, I'm going to get us to look at one very important thing that happens in our lives. Yes, we are happy when we go into marriages, for better or worse, and it flourishes so very well. But if something goes wrong and would have to get that marriage dissolved, what happens to the assets that were acquired prior to the marriage, during the marriage, and probably even after the marriage? We're focusing on Ghana and England, and the topic says, for better or worse, but not my assets. And I want to say thank you very much to BWF Solicitors, our proud sponsors and our benefactors who have been supporting us all throughout and bringing us this wonderful program. BWF Solicitors, are trusted partners when it comes to the law, are located on the 4th floor of the Anna House, 214 to 218 Tottenham High Road, Seven Sisters, North London, London N15 4NP. They work from Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. Call them now and bring everything that you would want to discuss or have support in the law to them. 0208 493 7340, 0208 493 7340, or 077 127 61884, 077 127 61884. BWF solicitors, yes, you can trust them. When it comes to the law, with over 30 years of solid practice behind the senior partner, you can't go wrong. They are 95 to 99% successful in any case they pick up, so you can trust them. Now, when it comes to bringing us updates about our stay here in the UK, the law of UK and the law of Ghana, then definitely you go into the right place. BWF Solicitors. Now, before I introduce my special guest and, of course, my resource person for today, let me pay tribute to BWF Solicitors, and I'll be right back.
Our private client services team is recognized for providing clear and practical legal advice to our clients in the United Kingdom and Ghana. Expert help with will writing, probate or estate administration. Our will writers and probate lawyers can act for you to obtain grant of probate and carry out estate administration on your behalf. The probate takes place after someone dies. If there's a will, the named executor is responsible for ensuring that the estate of the deceased is secured, assessing its value and paying any inheritance tax. If there is no will, the intestate and inheritance rules require similar responsibilities. Our lawyers offer strategic and practical solutions to the issues which clients face, whether it's in relation to succession planning, will preparation, probate and the administration of estates, immigration and visas, contentious family or probate disputes, administering estates often with inheritance cross-border issues, international trust advice including residence, domicile issues, wealth preservation, a fast, efficient service from SRA-regulated professionals, transparent pricing. BWF Solicitors, let us take care of probate.
Welcome to City of Favor Estates, developed by Sarenano and Sons Company Limited, located in Tema Community 25 extension off the Tema Aplau Road. City of Favor Estate offers 2, 3, and 4 ensuite bedrooms on 118, 138, and 178 to 190 square meter lands, respectively, to give you the needed space. Our gated estate homes are designed with you in mind and have all the necessary amenities located in a serene environment with security. You too can be a homeowner at a price that suits your budget with flexible payment terms. Choose City of Favor Estate for peace, comfort, and safety. Reach us on 0542 563 250 or 0243 235 518.
This is our world. Here we are in our community. There are the laws, there are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214 to 218 High Road at Seven Sisters in North London, N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
Okay, well, thank you very much. Let me do my housekeeping now. We live on BWTV, live on BWF Solicitors, all the social media platforms, Facebook, YouTube, LinkedIn, and all the others. Tilly Duma, you are right there with us, and you saying, are you calling up Namponsa? Lyrical Black is here. Good afternoon, Uncle Kweku. Yes, Uncle Kweku is here, but I am with another uncle, so I'll be introducing very soon. Albert Danfo, you are here. Tilly, thank you very much for doing the job and asking people to share, and share. So if you have joined us now, please, if you are a first timer on this channel, just go onto the bottom of the page and like the page and click on the notification button so that when we put up any content, you will be notified. Then also when you have any question, any concern, any issue to raise with us whilst we're having the discussion, or you want to ask the lawyer any question, just put it in the comment section of your page, either on Facebook or on YouTube. Jima Bwachi, special greetings to you as well. Where are you watching us from? Let us know. So when you come in, announce yourself and let's also know where you're watching us from. Eric Kwabna Sante, thank you for joining us. Nana Bobasari, we're calling you. Come on board and let's do this together. It's live on BWTV and of course BWF Solicitors Facebook and YouTube. Now this afternoon, the question I am asking is very interesting. You love somebody. You fall so much in love, head over heels with a person. You agree between yourselves and the families also agree and you get married. If things go pear-shaped and the marriage is to be dissolved, what happens to the properties you had before the marriage, within the marriage, or during the marriage, and probably after? What happens in Ghana? What happens in England? I am privileged to have one person who is so well versed in family law to help us look at this. He's no other person than the principal and the senior partner of BWF Solicitors. I'm talking about lawyer Bennard Owusu, Uncle Ben, as we usually know him to be. Uncle Ben, good afternoon.
Hi, good afternoon. It's an
Thank you very much for
absolute
joining us.
pleasure to be with
It's
you
a
this
lovely
afternoon.
Saturday afternoon, even though it's a bit rainy and windy. We have it so very lovely. How are you?
I'm doing very well. It's an absolute pleasure to be here with you and with our viewers and also our listeners. We're very grateful that you've all joined us, and we hope that we will have a fruitful discussion today. Contributions from you will be very helpful, either calling or send a text or WhatsApp or whatever, and we will pick up your questions during the interactive session.
All right. Thank you very much. So, folks, get ready. Ben is ready to lead the discussion and he's inviting us to come in. Your contributions, your questions will make it as lively as we want that to be. In the meantime, there are a few updates that we want us to all look at. And the very first one we're looking at will be Nuggets. And there's something the Supreme Court has recently put out. It says it's recently decided that financial relief or settlement applications end automatically if one party dies during the legal process. The court decided that the rights to apply for financial relief or personal rights and obligations that can only be adjudicated between living parties. Anga and another in substitution for Hassan appellants versus Ol Hassan deceased and another respondent of 2023 UK Supreme Court case 2022 is what I've quoted here. And it sounds very technical, but I know we can bring it down to our level. So I'm inviting Uncle Ben to help us with that. What does this say, Uncle Ben?
Okay, Kweku, this case has been long in coming. I was doing a very famous case. I don't want to mention names because the court put um, an injunction on reporting of the case because there are kids involved. It's a very, very famous case,
Right.
which I was involved in. And we've been waiting for this decision since March this year.
Oh, okay.
They had a case October or September last year, and it's only recently that the Supreme Court has made a determination. Basically, what that means, in this case, I think the case started from Saudi Arabia, and they chose a financial settlement forum to be England. And during the process, unfortunately, one of the parties passed away, and the wife or the ex-wife wanted to proceed or continue with the case. So the Supreme Court had to come in. The appeal went straight from the High Court straight to the Supreme Court for the Supreme Court to make a final determination. There are previous judgments that lean towards proceedings still continuing. All that it says is that litigation and financial matters is between living persons. And if one of the living persons passes on, unfortunately, proceedings must be brought to an end. And basically, that is the summary of the decision.
So it means that if, to the ordinary person, if I owe somebody tons of money and the person unfortunately passes on, then it means that the case is ended and I can go scot-free with whatever I owe the person.
No, that's not a law. So this is specific to financial dispute matter.
Okay.
And I'm trying to be a bit careful so that I don't give a lot away. The case that I was involved in was on married partners, and the mother had 3 children with a young man, a very famous person, and the case had gone to court. There had been an injunction on his international assets, several millions of pounds, and in relation to assets here, there was injunction, although he was getting money from the other solicitor. They were releasing monies to him on a regular basis. And the mother, who was unmarried to this young man, had gone to court for child maintenance. So the court made an interim award of paying the children's private school fees, giving them money. I think a month we were paying them about £25,000 a month.
Okay.
And that's how much he was paying. And unfortunately, he passed away. And obviously, our position was that once he's passed away, the case falls away. And therefore, any judgment that has been made against him will not stand. Because this judgment delayed, families got involved. There are young children involved. I think the youngest is about 3 years. The oldest is 11 or so. So the family decided that, listen, whether or not you don't have a right in law because one of the parties is passed on, we are happy for you to continue to receive the money. I think at the time we had about $250,000 with a firm of solicitors, and that money was released to them. But the case was worth several millions of pounds. So if the other side of the family have said, well, that's it, everything is finished. This judgment clearly says that yes, that is it. The judgment is finished. Although that you can bring an action under the inheritance rules for provision of children, and there will be a fresh action against the estate. Now, in the scenario that you gave, if I owe you money and I passed away, yes, that's it. You cannot bring an action against me because I'm deceased. But you can bring an action against my estate. And, those are the nuances that we have to bring to bear on some of these cases.
Right. Well, folks, if you just joined us, we're looking at a Supreme Court ruling that has come out, and as Uncle Ben said, is being involved in this case, and we're waiting for this decision to come out, and it's come. So credit to him and to the court as well. Now, the Supreme Court has recently decided that financial relief for settlement applications end automatically if one party dies during the legal process. So, you can litigate with a dead person. You can charge those things against the person's estate, but if the person is dead, you can litigate against the dead person. That's as simply as that. Well, we are going to also ask Uncle Gwen another thing. I hear that the UK government is trying to introduce this fee against immigration and the rest of it to finance the NHS. Uncle Ben, what's happening?
Okay, so I mean, this week we had our prime minister. Was it last week? I think it's last week. We had our prime minister Rishi in Parliament setting out his vision, and he had been tough against adding any more money to the 3.5 offered to the public sector, especially to the medical staff, doctors, junior doctors, and he needed to cave in. And 3.5 wasn't acceptable. He then offered 5%. 5%, the initial offer would have cost, I think, 5 billion a year, and obviously he needed to pay more. So they needed extra money. And lo and behold, where do you get the money from? From the
Immigration.
people that have been abused over the years, those who have held our country together, built our railways, and continue to hold our country together because we provide the most essential of service, including from medical care, carers, nurses, teachers, cleaners, rail workers, tourism. Every single aspect of British life was helped built by migrants. We continue to rely on migrants. We are all migrants, and the services we're providing to the country is enormous. Unfortunately, there's a soft spot for politicians. They get hit, they get taxed, and they get cheated. So although migrants, will be here lawfully and working, yet when they're going to renew their visas, they still have to pay towards the NHS, and it's called the immigration health surcharge. It started very low. It's now £634 a year. It's going to go up to 1,035, I think. We believe during September, it could be earlier than that, is to plug a loophole. And they're looking to raise about £1 billion from people who are already working and paying taxes. So all the fees are going to go up. The surcharge is going to go up from 1,560 for 2.5 application to potentially almost 3,000, just under 3,000. And for applicants who are making FLR applications or settlement applications, they are all going to go up by 15%. So the current fee for a 2.5-year FLR FP is about 1,044. If you add 15%, you're potentially looking at about £155. So that would be about almost 1,200. Settlement applications about 2,300. That's going to go up by 15%. So that's about 2,600 thereabout. So all facets of application fees are going to go up. And my advice to people is that there are schemes in place, especially for those who are applying for limited leave to remain, purely under private or family life, because it's human rights application. The law allows you to make an application for fee waiver. And that's what we encourage everyone to do. Whether you're working or not, the determination is whether you can afford the fees. I'll give you an example. Typical 2.5 years, possibly from September, you're now paying about 2,608. You're going to pay about 3,000 plus. If you're two, that's over 6,000. Now, I don't know who can save that money as quickly as possible at that level of work. Of course, there are people who are extremely rich, but most of our community members will earn the average income, which is about 24,000 a year. Your take home is about 1,006. You're potentially looking for a 2-bedroom apartment anywhere in London. You're looking about 1,500 to 1,800 pounds a month rent. Council tax will add about 150 a month. Already that's eating all your income. Groceries and food, shopping, utilities have income, travel to work. If you're paying for private child minding for your child, and again, that's money that you can't afford to spend on applications. So any person who is working, whether you're earning thousands of pounds or hundreds of pounds a month, I would say to you, if your application is a qualified application, which basically means that you're making a human rights application, then please apply for fee waiver. We've done two videos to help you apply for the fee waiver. It's very easy to apply, but the emphasis must be on you providing evidence that you cannot afford the fees. So if you're somebody who freights away money, I've got a client who borrowed £8,000 and spent 6,000. So just on the face of it, you might think, oh, they've got a lot of money. So why are they asking government to pay this money for them? But they've used the money to buy white goods, a fridge, freezers, microwave, blenders, a TV, and also they bought furnishing and furniture for their home. They've moved to a new home, and all the money is gone. It's borrowed money. So that's why I keep saying that it's not only your income, but it's also your expenditure. As with everything, it is what you spend the money on that they will use to assess you. So, Kweku, that is what is coming, and it is coming. It's been
So there can't be any pushback at all, can they?
No, not at all. Because the Prime Minister said he's not going to borrow or increase taxes. So he's gone for the softest of spots or the lowest hanging fruit. They've been plugging us since time immemorial, and they keep plugging us to plug their loopholes, but they continue to do that. I'm afraid it's what it is. We also have to be sensible. We need to use the things that are available. The Asians do it, and they do it extremely well. We should also do it. I mean, a typical Ghanaian will tell you, oh, lawyer, but this is not going to JDSK. This is basically you falling on your entitlement and your right. It's a right. If you can't afford it, then it becomes a right. It's not a privilege, it's a right. And you have to be entitled to it.
We're live on BWTV, and the program is The Community and the Law. Our resource person, Bennard Owusu, who is the senior partner of BWF Solicitors, is helping us to look at the topic that I'm bringing up. And we're looking at, for better or worse, but not my assets. We're looking at a situation where the marriage is broken and resolved. And we are going to look at how the law divides assets between the partners when there is a divorce. If you are ready, just call other people, let them know that the discussion is live on. Share the page, pick it up, and let's go on together. BWF Solicitors, 214-218 Tottenham High Road, Seven Sisters. Call them 0208 493 7340 or 077 127 61884. Now, if we're going on the discussion and you want to send in a text or a WhatsApp, text number is 07399 208 468, 07399 208 468, or you can send a WhatsApp message to 07950 422 780, 07950 422 780. Kweku February, you're asking for the number. It's on the screen now at the moment, but I want to repeat that. If you're calling, it's 07399 208 468. And if you want to send a text, you can send a text to that same number, 0739 208 468. But if you're sending WhatsApp or a voice note, send it to 07950 422 780. 07950 422 780. David Asamoah says, God bless Uncle Ben and team for all insight and the hard work. Rebecca Mwako comes in with, good evening, bro. Good evening, Becky. How are you? Lyrical Black. Yeah, we send a link. Probably you're not checking. It says, today, dear, you sent me the link. Thanks for free legal advice. Yeah, we do that. So if you don't receive it, please prompt us and we will send that to you. Lyrical Black, again, yes, you greeting us saying thank you. Abba Downfall, you are live with us. Thank you so very much. So keep liking the page and let's get a lot of likes as much as possible. Let the algorithm look very good and get people to benefit from all the experience and knowledge that Uncle Ben will be sharing with us. Uncle Ben is going to help us to look at the situation for better or worse, but not my assets right after this.
This is our world. Here we are in our community. There are the laws. There are the regulations. We have BWF solicitors. BWF solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214-218 High Road at Seven Sisters in North London. N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
Okay, now we're back into our stride and we're going to the discussion straight away. Question is better or worse? Uncle Ben, when we get people to get to attend our weddings and our marriage ceremonies, we talk about whatever it is. I'm going to be faithful to you. I'm going to love you as you are, for better or worse. But unfortunately, sometimes it goes bad and things happen. I struggle to ask this question, but when marriages get issues and problems, do they necessarily have to be dissolved?
Well, quite cool. It's it's a legitimate question. I would have thought that two grown-up adults, would have been together for years, possibly, and if they've come to a point where there are issues and stresses in the marriage, sometimes it might be issues that can be resolved, and most often than not, they are implacable hostilities. And you would have thought that two people who love themselves maybe a few years ago have suddenly fallen out, and the aggro and the vitriolic statements from each other towards the other become such unbearable spectacle for the children. And you want to consider the welfare of the children in some of these things, and also the mental health for the parties. And unfortunately, if it comes to those issues, then the tension will be such that the parties will have to part their ways. It's usually done with a bit of sadness and situations that we have been involved in. Obviously, very difficult situations, but usually would have taken a long time for the couple to ponder. May have tried what we call trial separation. I slept in different bedrooms, gone for counseling, and relate. As you know, deals with marriage counseling. I don't know whether our Ghanaians do go there, but yeah, it's still there. Usually will be church and then it becomes unbearable, and irreconcilable differences obviously leads to a break instead of a crack. Yeah.
All right. Now, I'm looking at it from this angle. There is one, or there are two people who may have acquired their own assets through their own right. They come together and they put resources together to take care of their children, to make sure they are living very quiet, comfortably, and the rest of it. But if unfortunately it has to be dissolved, can't I say that I came in with X, so I'm going away with my X, and probably a bit more of what we have achieved together, which is X and Y, so then I go away, rather than one saying that I'm taking this away from you because I am in marriage and I'm entitled to that. It brings in that complicated situation where it gets so many people bitter. What do the laws here in the UK and Ghana say?
Well, and that's why we're having this program, because for us as community lawyers, we like to educate, share, and inform. It's very important to us, because that is the only way you can get your community to grow. Because if parties understand that this is what is likely to happen, then maybe they might think twice.
Before
And
going
I
into
know
it?
ask about prenuptial agreements. I mean, if all your assets is 200,000 or 300,000, I'm not sure why you want to think about that. But Kweku, the law has developed, and the UK has developed. It's taken several years to reach where we are, with the latest Supreme Court case, Miller and Miller, White and White. They've brought us in a case of XZY, Chinese case, which the High Court recently promulgated, in, dealing with matrimonial assets and what is not matrimonial asset. So I would take the basic law. The basic law for distribution of assets in the UK is dictated by the Matrimonial Causes Act, Section 25. The basic law for distribution of assets in Ghana is also the Matrimonial Causes Act. But in the case of Ghana, the Constitution, which is the 1992 Ghanaian Republican Constitution, Article 23, also says that assets acquired during the marriage should be shared equitably or fairly, which is 50-50. Now, in the UK, the starting position was that whatever you brought into the marriage, you keep. And then that developed to the three basic needs: compensation and sharing. So the English position now is dictated by three headline items: needs, compensation, and then sharing. Now, when you look at Section 25 of the Matrimonial Causes Act, the court has listed about 14 items that the judge must take into consideration when he's making his pronouncements on any of these three headline items. So it will be ages of the parties, capacity, which will be earning capacity, any disability, including mental health issues, earning capacity I've mentioned, the needs of the party, the ages of any children, the length of the party, the behavior of the party, and certain aspects. It's a 14-item list. But the court will have to look at, if I mention needs, so when you have a wife, a husband, and you've got young children, the needs of that family will be to meet the accommodation or shelter, food, and other things for the family.
Mm.
The items also include standard of living, and I also mentioned behavior or conduct. The Ghanaian position is fairly straightforward, as dictated by the Constitution. But the English law now is that at the time that you dissolve the marriage, if the parties are going to share their assets, then they have to check whether the assets will be shared by needs, by compensation because somebody has suffered. And I'll give you an example. For example, I take myself always as an example when I'm advising my clients. My wife and I, our kids were very little. She was working in a law firm in Ilford. I was a partner in one of the biggest legal aid firms in South London. I was a young man, we were in our 30s. So we needed to decide what was important to us because she was always rushing to work. She's either late for work or late in picking the children from nursery, although we changed their nursery close to where we live. But she had to travel from Ilford into Essex. So the decision was made that, you're a legal executive. She was earning good money. I was earning good money. But then we needed to concentrate on our children because we didn't want to sacrifice their welfare.
Right.
So when it comes to compensation, thank God that, we're married and we're not divorced. But when it comes to compensation, that is the argument that she will use. That you
Okay.
made me stay at home to bring up our children, lovely gentlemen, and my daughter, and I brought them up to a standard where, they've gone to university, they've all got their careers now. So the court will say, well, you will have to compensate it. Bear in mind that I've worked, I've earned, maybe I've been a naughty man, I've gone, maybe have kids somewhere, enjoying myself, the champagne lifestyle. She's been home looking after the children.
Right.
And that is the compensatory aspect. The needs aspect is party without typical low money case. Assets usually will be maybe a council flat or ex-council flat that has been bought. Equity in there is about 80, 70,000. Man is working, earning about 25. Wife is working about 23. So there's needs there. The needs is for the children. So when it comes to distribution of assets, the woman can take the council flat, which they now own, and the man will be asked to make some payment towards the welfare of the children. So child maintenance may contribute towards the mortgage and stuff like that. Or sharing. So the sharing aspect usually will be marriages where maybe a long marriage, possibly all the kids are old, they've left home, they've flown the nest, as the lawyers will say, and then there will be a sharing aspect. So the sharing, when we say equitable sharing in England, is not 50-50. Equitable sharing means what is fair. So what is fair may be 60-40, because if the man or the woman was earning more than the other party, or the earning capacity of the other party is very low because of sickness or disability or the educational background, or the other person has developed themselves so much that he now can earn more than the woman, then although sharing is there, but the sharing aspect will not be 50-50. It might be 60 to the woman and 40 to the man because
So
the man has.
who would determine the ratios? Would it be
It's
a
the
judge?
judge. It's a judge. It's a
Okay.
judge. But we as lawyers are able to predict what the general distribution will be. We may be able to tell you you're likely to get below 50%. That will help with the negotiations because most of these things are negotiated. A lot more goes through to final determination. So we will help and then we draft all the consent agreements. But I've talked about England. I've talked about the case of White and White, Miller and Miller, McFarlane and McFarlane, to the recent one, XZZ case, which I think, we shared last week or the week before. And these are cases that determines what is likely to happen. With Ghana, it started with a case of Quarty versus Mate, where Oleinu in 1959 said under customary law, you won't believe what I'm going to say. Under customary law, a man marries for his wife and children to work for him and to assist his endeavor and his enterprise. That was the decision in 1959. So everything you've done in the marriage as a woman, you don't get anything.
Oh.
Yes. And then we moved on to the case of Quarty and Quarty, where, you know, it was a bit nuanced. I think that was 1989. And then thankfully we came into the 1990s, where we had the first Mensa and Mensa case, and then Gladys Mensa, and then we had a Mensa and Mensa 2, where the Article 22.3 of the Constitution was interpreted to mean that there should be equitable distribution of marital acquest. So when we say marital acquest, those are assets that have been acquired during the marriage. Before, the courts looked at contribution. So you need to prove that you contributed towards this asset during the marriage before you can share in it. But the courts have moved away from that in the case of Mensa Mensa to the latest case this year by the Supreme Court 2023, case of Anyete versus Anyete, where the court has clarified everything and said, listen, any marital acquest should be distributed 50-50. Any marital acquest. A marital acquest is anything that is acquired during the marriage. Okay? But you can lead evidence to the contrary to show that although this was acquired during the marriage, it was only my contribution. It's possible, but the default position is that any marital acquest or marital acquired asset should be distributed 50-50 under the Ghanaian law. The English law is similar to the Ghanaian law, but it's taking the Ghanaian judges, very bold Supreme Court judges, to bring the law this far. The Parliament was, in fact, entrusted by the Constitution to draft a law to deal with this aspect. They haven't done it. Typical with our Parliament, they rather discuss extraneous matters. They don't talk about the things that are important
affecting the Ghanaian family, a very basic fabric.
Yeah. And that's why I said that the Supreme Court judges have been very, very bold. And on this matter, I'm so delighted that the court has come into the 21st century. I'm not sure whether we are in the 22nd century, but they have brought everybody screaming and kicking to the 21st century. And the law in Ghana is that any asset which is acquired during the marriage should be shared 50-50.
Okay, so 50-50. If there are situations where, like the English law, there should be compensation because one person would have sacrificed to keep the family together and the other person had worked. How do you value the person that sacrificed to the one that probably went in to bring the physical cash and the assets in there? How do we value that?
Yeah, I've written, I think, a 6-page article which should be published, I think, in the next few days on our social media. And that deals with this very important question. First of all, the English law will look at 3 headline items. So the decision will be either compensatory, because of what you've mentioned. It will be for sharing, because there's no needs-based, children have flown the nest, they've gone, or sharing. And all will be dictated by the items listed under Section 25. The court now, in the case of, ZYX, clearly says that for fairness and equity, where someone's behavior is what has caused the marriage breakdown, person was doing gambling, wasting money, sending hundreds of thousands of pounds, spending on gambling, sending money away, wasting money, maybe drug issues, spending thousands of pounds on drugs. That is a conduct issue, so you can get compensation for that. Maybe when you bought the property, you put in a bit more of the deposit. Let's say you bought a property maybe 20 years ago, was 230,000. You put in about 40,000. The woman didn't put in anything. But subsequently, you've all worked together. You've looked after your family. Do you get compensated for putting in that big deposit? Again, it would depend whether the children have left home. It depends on the needs of the parties. It depends on the earning capacity of the parties, whether there's disability. Those are the nuances that you need to value and put in the case when you're running with these cases. In Ghana, it doesn't work like that. So the Ghanaian situation is where these assets acquired during
During
the
the
marriage.
marriage.
If so, the starting position is 50-50. But you can depart from that if one party can prove that, no, this one cannot be 50-50. If you look at the case of Anyate versus Anyate, there was a business asset involved in the case. The High Court judge said that the Ghanaian courts do not have jurisdiction over foreign assets. The Supreme Court said there's no bar. The Ghanaian courts will have jurisdiction over assets of the parties anywhere in the world. And therefore, the business was valued. And although it was said to be a business asset, it was still an asset which was available to the parties. And in that case, fairness and equitable distribution of the assets was what was applied. If it's England, it might be different. But again, the circumstances are different everywhere. The law is similar because Ghanaian law takes from the English law, and now the pronouncements are similar. But the Ghanaian emphasis is on assets acquired during the marriage.
During the marriage.
English law emphasis is on acquired during the marriage, but in certain cases, assets brought into the marriage and assets acquired after the marriage can be brought together into the pot to be distributed if there's not enough to go around during the distribution.
I know that there are people who may find themselves in this scenario that I'm going to create. I have my partner come with me. We have acquired assets, business, and properties outside of the UK. We have acquired assets, business, and other interests in the UK. Unfortunately, the marriage is broken down, and these are acquired within the marriage period. Which of the jurisdictions would take precedence over the other? Which laws are going to be used in distributing these assets?
Okay, so the English courts are a bit cautious when it comes to making determination about foreign assets.
Mm-hmm.
So there's a case that I'm dealing with. We're likely to go to court because of fraud. And in that case, there were farmlands which were valued at £200,000. Their matrimonial home here was valued at $850,000. And then there was a business that is alleged that the man had, which was valued again at $150,000. So the pot available to the parties was about 1.5 million. This was a lawyer and a driver. So my involvement is basically to advise and to represent. Now, when the determination was made, large part of the assets were in Ghana. What the judge did is that he valued all the assets, about 1.5 million. The one in Ghana was 750. The one here was 750. But he wanted to give more, about 80% to the woman. So you know what he did? He gave all the properties here to the woman, plus a payment of a top-up payment to bring her to there, and just left the Ghanaian properties. Because the court said that enforcing said judgments in Ghana, although Ghana and UK, well, not Ghana and UK, Ghana and England and Wales have reciprocal agreement in this matter. So you can take that judgment from here and go and enforce it in Ghana if you decide it at the High Court. The judge was cautious that the wife might not be able to enforce the judgment in Ghana. So instead of saying, I give you all the assets here and half of the one in Ghana, he said, I give you all the assets here, plus this man must pay you an additional amount of money. And if he doesn't pay, then we'll have to come back to court and see what we'll do with him. So if you read my article, you can see that I'm leaning towards England for post-divorce distribution of assets, because there's clarity, there's certainty, and the law is a bit fairer to women, and the men will always prefer Ghana, but very soon they will know that the judges in Ghana have also moved towards equitable distribution, and they are very fair when it comes to these matters as well. So,
Well,
if you ask me, where will I lean towards?
lean towards, yeah.
I will lean towards England, yes.
Uncle Ben is just announced that he's written an article that will be published very soon in here in the UK, and well, it could be accessed all over the world. So watch out on bwfsolicitors.com, www.bwfsolicitors.com, or visit the Facebook page of BWF Solicitors or YouTube page of BWF Solicitors, because there will be a snapshot of that article in a video that will be posted on there. That's why I'm asking you to subscribe to the channel and click the like button. Of course, get all notifications when anything is put on the channel. We're live on BWTV and we're bringing the community and the law. This afternoon, we're looking at situations where marriages break down and when they are dissolved, what happens to the assets that have been acquired during the marriage. Even after the marriage, there are certain situations that these are brought in for the distribution. And we're talking about equitable distribution and looking at several scenarios where the criteria and the formula will be generated. Uncle Ben is giving us the Ghanaian situation, is giving us the English situation, and we're looking at all that. Division of assets in divorce, focus on Ghana and England, and is live on BWTV on the community and the law. We'll be right back.
This is our world. Here we are in our community. There are the laws. There are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214-218 High Road at Seven Sisters in North London. N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
Thank you, BWF Solicitors, for your kind sponsorship and support. And we want to announce that if you have a text, send it to 07399 208 468. If you have a WhatsApp message or a voice note, you can send that to 07950 422 780. 07950 422 780. The lines will be active very soon. We'll announce that. But in the meantime, you can send your comments to the chat on our Facebook page and YouTube page, and we'll pick that one up. Sales B, you're watching with us. Thank you very much. Willie Achampo Akolo, you're watching. Yao Wache Ajiman, thank you very much for your time. Joyce Equia Efriye, Frank Braco, and the host of other people who are live with us on YouTube and on Facebook, we'll say thank you very much. BWF Solicitors, call them now, 0208 493 7340, 0208 493 7340, or 077 127 61884. This afternoon, I was just speaking to somebody and it was like, Are you a solicitor? I said, well, I'm a de facto solicitor. But the question was, how can I get somebody to understudy Uncle Ben for all the good works he's doing, the rest of it? Listen, Uncle Ben has an open door for training young and upcoming Ghanaians and other people of African descent who would want to excel in the law field. So get in touch with BWF Solicitors. There's that opportunity for you to be able to explore all the avenues in law and also practice so very well. And Government does that, BWF Solicitors does that. I'm going to the next line of questioning. And Uncle Ben, I'm coming to ask and find out that we have been educated, your good selves and your firm have been educating us that if you live in the UK continuously at least for a year, that we say you are domiciled in the UK. If there has to be a divorce proceeding, whatever, you have to do it here in the UK. I'm looking at the situation where people have access in Ghana, access here in the UK. If I'm filing for divorce, where should I go?
Well, first of all, if you're filing for divorce under the Family Law Act, Section 46, if you've been here for more than 12 months, then it has to be a court process divorce. So it can be filed anywhere. You can file it here if you're here. If you've ever lived here, you can also file it here. You can also file it in Ghana if you've lived in Ghana or you're a Ghanaian national. So you can file it anywhere once it's a court process divorce.
Okay. It looks like David Adupoku is taking the wind out of my sail, and he asked a question that I'm going to look at again. Now, David is saying that I'll be bringing that in quite quickly. Is brought in this one. I'm really enjoying the program. Thank you very much, David. Whilst I appreciate the focus on estate after divorce, how about liabilities such as debts?
So in the distribution of assets, liabilities are always considered, because when the process starts, you get a financial statement which is sent. It's called a Form E.
Mm-hmm.
As part of the documents that you complete, you have to put your liabilities, including loans, mortgages, car loans, lease, and hire purchase. So that obviously, depending on how it was incurred and what it's being used for, will be taken out of the available resource before the sharing is done.
Okay. And if I am not satisfied with the outcome, I'm not satisfied with the formulas that are used, I think that I need to be compensated a bit more. Can I litigate on?
Oh, yes, yes. So you can always appeal from the family court. You've got 21 days to either go to the High Court, or you might go back to a master, or you can go to the Court of Appeal. But litigation is very expensive. We just concluded a long case, and somebody else wants to appeal. I mean, the cost alone, we estimated about £20,000 just for drafting and lodging and one hearing. Because appeals, if it's a court of appeal, you're potentially charging between 350 and £500 an hour,
Mm-hmm.
and it can be very expensive. But as I said, I mean, there's a case that I'm dealing with now that I explained a bit of, and although one of the parties didn't appeal, we've just identified potential fraud. So because of the potential fraud, it can reopen the case. It may be that one party hid some of their assets, and that wasn't taken into consideration by the court. And therefore, matters of that nature can be litigated.
Oh, okay. And can I also ask that we take the thing out of court and settle it amicably between us rather than the judge giving us the ratios to use?
Well, I mean, first of all, as with every litigation, the family proceedings requires us to do a MAM, which is mediation. So all the parties, before they can issue any application for matrimony under the Matrimonial Causes Act or the Children Act, will have to go to mediation, unless, of course, they come under one of the exceptions, which will be because of domestic violence or a particular urgent nature of the case. So mediation is encouraged. I mean, cases don't just go to court. There's a case I'm involved in, and it's worth about 2.2 million. It's been running since COVID started, so that would be 2020 December, and we are now in 2023 July. We've done everything possible to prevent litigation. The other party is, represented by a lawyer who doesn't seem to understand what the law says in this area. But we haven't gone to court because our client is an elderly person who hasn't got the money yet. He's raised a bit of the money. So you can see that the preference in this case was for mediation because it can be very expensive. I mean, this case goes straight to the High Court. We're charging him, about, I think, 80% discount. So, nothing much. But counsel is charging about $350 an hour. And if we were charging our fuel fee, we'll be charging the same rate as a barrister plus VAT. You're potentially looking at over £400 an hour. I mean, that can easily go up. £400 an hour. If I write a one-page letter to you, that could cost as much as £40. Clearly, settlement out of court is advisable to every single person. And, I belong to a group of lawyers called Resolution Fairs. And our main focus is to try and minimize litigation and tension in litigation when it comes to family matters. But unfortunately, there are cases where, like the one that has just come back to me again, where, the woman withdrew the case from the court. The man then took the withdrawal to Ghana, told everyone that he won the case, sacked the woman's sister from the home that they built together. I think it's a 6-bedroom house in Accra. Her sister now doesn't have anywhere. I told them for her to go back. She went back. The man sent, youth, about 15 of them, to go and make noise in the house. So it means that we have to go back to court. And already, she spent several thousands of pounds on this case. So we try and encourage people to settle if they can. But certain cases, you cannot settle. It means that you have to go through. And it's very, very expensive.
Right. Now, there's also this scenario where somebody was served with a divorce, whatever, and the decision was that the marriage was dissolved. There weren't any issues of asset distribution and the rest of it. He sits back years after and thinks that it wasn't fair to him. Can you open a case like that? Can you open a case like that?
Yes, you can always apply for financial settlement, but the problem starts when the other party or one of the parties marries. So once one of the parties marries, then it becomes a bit more difficult to go back. You still can, but your access to the court is a bit limited. And therefore, we advise that before the marriage is settled finally, if there are any financial settlement issues, we deal with it either by consent or by litigation in court.
Okay. The lines are active now. You can call in, and if you have any question, you can put it to Uncle Ben as we soldering on. It's 10 minutes into the second hour. 07399208468 or 07950422780. That is for WhatsApp line 07950422780. 07399208468, and that's for lines, active lines. So if you're ready, you can come in here. Now, Uncle Ben, are a few of the comments on there. Kwajutu4 says he's watching live. Thank you very much. Where are you watching from? There's this one that I want to put on. My sister is living with her husband in the UK. They want to bring their children from Ghana to the UK. The father has settlement. How much for the application fee for both children under 16? I think that's an application thing. Can you quickly help us, Uncle Ben?
If they want to bring their child from Ghana and the child is under 16, then depending on what the status is, they can either bring the child under a 297 application, which is for settlement, indefinite leave to enter, or indefinite leave to come to the UK, or they can apply, if one of them has got limited leave, they can apply under Appendix FM for 2.5. What I've always said, what the father has is indefinite, and the both of them are here, so they meet the requirements of both parents being here, and it will be very easy. The child will be given limited leave to enter, and it will be in line with the mother's current status. If the child was coming alone to the father and the mother wasn't here, then they will be looking at indefinite leave to enter. But it's a very easy case. They only have to comply with a maintenance requirement, which for somebody on a limited leave is 18,600 plus the first child is 3,800. If you add up, I think it's about 22,400 or so, which would be the household income to enable the child to come.
Well, Uncle Ben, there's this question that's come through. I was trying to put that on there. Now, this person is saying that we're talking about assets during the divorce proceedings and settlement in that. What about children and custody? Are those situations considered when assets are being considered as well?
What is that? Custody?
Yes.
Yes,
Custody of
and
children.
you see, for the English courts, this are prescribed discretion that the court has. In Ghana, they will always look at child maintenance separately from distribution of assets, because when you're distributing assets, it's an interest in the property that you're distributing. With any interim order or an order to make a payment to a child, that will be money coming from the man's pocket. The law looks at it a bit differently in Ghana, whereas in the UK, it can be part of the total decision. So, for example, if the net assets to the parties is about £500,000, and the judge was looking at equitable distribution of 60-40, but the needs of the child is that the child has maybe a particular need, either he goes to private school or there are things that he would need, the judge can capitalize that child maintenance and say, well, instead of me giving you 200 and her 300, I'm going to give you 100 and I will give her 400,000 because I want to capitalize the child maintenance, which is possible. It can be capitalized. The case that I was involved in, where the young man died, it was they were looking at capitalization of the maintenance because there were several millions of assets and money involved. Yeah.
Okay. Well, this person is was asking how much for the application fees for both children. I think the very first question we put on was asking, the sister is living with her husband in the UK, want to bring their children. So he's looking for the application fee for both children under 16 years.
The children get a discount for IHS. I think their fee is about 400 and something instead of 600 and something. But the normal 2.5 years they will give them to come, it's just over 1,000. So when you add that, I think potentially you're looking about just over £2,000 for each of the children.
Okay.
To come on a limited leave to remain. Yeah.
Okay, all right. Let's see. I hope your question has been answered now. This one here says, "Good morning, Uncle. Well, dependent of an EU on working full time, and my time is due for renewal. My dependent father doesn't give me any money or anything because I'm in full time employment. My bank and employment are connected to his address. Is there any advice or something I should do since I don't have any financial support from him?"
Well, he didn't. say his age, but once he's used the word dependent, I will assume that he's over 21. And this is a typical problem that we have in our community. We've talked about it year after year, hoping that people will spread the news that if you are an EU national and you brought a dependent, not your wife, but your child or your grandchild who's over 21, they have to be dependent on you. There's a case of Ali, which is just concluded. Very, very sad case of a child who was estranged from the mother, and she went to argue that under the withdrawal agreement, the UK government cannot change the law. She lost the case anyway, because the dependency rule must be throughout the 5 years of residence. If you're working, you're allowed to work, but where your income is more than what you need from your father, then it becomes a problem, because the determination of what the resource available to you for your essential living needs. So essential living needs. If you're working earning 1,500 a month, and all your father gives you is £100 a month, then of course you're not dependent on your father. You're clearly working. It's not too late. You can start doing the maintenance thing. And the advice I give everyone is that so yeah, Juma, your account me, scan about Kobefaha, now Wapadianafaha. It prevents them, you presenting documents that shows extra income coming in and your father's support. But if you haven't done that for 5 years, then start doing that now. It's not too late to do that.
Okay. The next one here is okay. Let's look at this. Although a circuit court judge in Ghana granted me ownership of a piece of land that is located in Adwas Redru, the relevant stakeholder at the Land Registration Division refused to obey the aforementioned judge's order by claiming that it is an interrogatory judgment. Could you please let me know the options available for compelling the relevant stakeholder at the Lands Commission to obey the judge's order? Thanks for your help, courtesy, collaboration, and anticipated response. Our brother is Emmanuel.
Yes. So interlocutory order means that it's not a final order. It's an interim order. That's what we call here, which is that it could be appealed immediately, or it could change. And these are things that could have been granted without notice, possibly without attendance. So it was granted in default. And now the other party may now have filed their responses, and therefore it's challenged. And that is why, the land registry is a bit cautious, because it's not a final order. But any court order which is directed at a person must be obeyed, although interim orders are appealable, and even final orders are appealable until it's finally resolved. If the order is directed at you, then you have to obey the order.
Right. So the lines are active now. 0739920848 or 0795042278. That's for your WhatsApp messages and text as well. 0739920848 0795042278. You can also leave your comments on the comment section down below. We're talking about Facebook and YouTube. Kojo24, thank you very much for your compliment. Thank you also for showing your love and being with us. Agreement, this person is asking, okay, the person needs advice. I'm not going to mention the gender. The person is saying that they want to either use the student route or the care worker route. Which is more convenient for that person? Hello, can you hear me?
Yes, I can hear you.
Oh, okay. Now, what I'm saying, I was saying, there's this person that sent in the question that wants to know whether to use the care worker route or use the student route, which is more convenient and beneficial.
Well, it depends on your circumstance. Just bear in mind that the care worker route leads to settlement. The student route does not lead to settlement. Okay. If we have those at the back of our minds, then that will help you make your decision. But as I say, if you want to study, then come and study. If you want to work, then come and work. I know for some people, all they want to do is, I want to come to UK. That's all I'm interested in. If that is the case, then it's really a matter for you. There are restrictions with students, restrictions on work, the fact that you have to pass your exams. All these are things that will affect many, many people. We know many people who don't even attend the course. So maybe if you want to work and earn money, then look to the skilled worker route, of which the care route is one of them.
Would a care worker who's come through the route be able to switch to become a student?
Yes, care worker can switch to become a student. Care worker can even be a student in addition to being a care worker.
Or so you're allowed to enter into education when you have had a contract to come via the skilled worker route?
The only restriction you have with a skilled worker is that you must work for the employer you came with, and you're allowed to do part-time with someone else in similar employment. Anything else you can do. You can go to university, you can go to school, you can study, nothing bars you.
But you're treated as an international student, I guess?
Absolutely, absolutely. Because
All
you
right.
haven't been here for 3 years and you're not settled.
0739920848, and I'm picking up your comments as well. Uncle Ben is here, and we're looking at this very interesting topic of asset division when there is a divorce. The way the question is put, I really find it very enthusing, for better or worse, but not my assets. Well, we have this message that I want to really put across, and that's about things we do in preparation towards our exit into the unknown, our wills and probate. Who helps you do that better? Listen to this.
Our private client services team is recognized for providing clear and practical legal advice to our clients in the United Kingdom and Ghana. Expert help with will writing, probate, or estate administration. Our will writers and probate lawyers can act for you to obtain grant of probate and carry out estate administration on your behalf. The probate takes place after someone dies. If there's a will, the named executor is responsible for ensuring that the estate of the deceased is secured, assessing its value and paying any inheritance tax. If there is no will, the interstate and inheritance rules require similar responsibilities. Our lawyers offer strategic and practical solutions to the issues which clients face, whether it's in relation to succession planning, will preparation, probate and the administration of estates, immigration and visas, contentious family or probate disputes, administering estates often with inheritance cross-border issues, international trust advice including residence, domicile issues, wealth preservation, a fast, efficient service from SRA-regulated professionals, transparent pricing, BWF solicitors. Let us take care of probate.
Welcome to City of Favor Estates, developed by Sarenano and Sons Company Limited, located in Temakomji 25 extension off the Tema Aplau Road. City of Favor Estate offers 2, 3, and 4 ensuite bedrooms on 118, 138, and 178 to 190 square meter lands, respectively, to give you the needed space. Our gated estate homes are designed with you in mind and have all the necessary amenities located in a serene environment with security. You too can be a homeowner at a price that suits your budget with flexible payment terms. Choose City of Favor Estate for peace, comfort, and safety. Reach us on 0542 563 250 or 0243 235 518.
Welcome back. Thank you very much for keeping faith with us. We moving and soldiering on. My special guest and resource person is the senior partner of BWF Solicitors. Uncle Ben is with us telling us what to do and what the laws in Ghana and England say about distribution of assets when marriages break down. We have got into the segment where you can send in your question, your comments, and you can ask him any question you would want to ask him when it comes to the law. BWF solicitors are 214-218 Tottenham High Road, 4th floor of Vienna House. They work Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. 0208 493 7340 and 07712761 are their telephone numbers. Now let's take this very question that has come on the platform, and I ask Uncle to help us with that. My mother is 20 years now in the UK. I yet to apply her 20-year long stay. She is over 75 years now. Please, the application is a straightforward thing that I could do myself. Also, can I apply for home office fee waiver for her, saying she has no money because she has no right to work here? Will she be able to have some support to earn a living here after the application is successful?
Okay. Well, I mean, first of all, the application is straightforward. Most of the application is done at the evidence gathering stage, which is that you collect all the evidence that confirms that she's been here for 20 years. So it's not just saying it, but it's proving it.
Mm-hmm.
You need to show for every single year that she is relying on to show that she was here. And usually it will be items like gas bill, water, electricity, tenancy agreement, bank statement, P60s, pay slips, hospital letters, hospital cards, GP records, loans, credit card statements. And most of these documents are official documents.
Mm-hmm.
And therefore, you will need to have these documents to support your 20 years. Once you've gathered the evidence, the next stage is to make the application.
Okay.
Long residence under 20 years is private life. Private life is a human rights application. So you will be entitled to apply for fee waiver if you can afford the fees. Remember that it's not only her income, but it's going to be the income of the person who's looking after her. So if she's your mother, she lives with you and you're working, you will have to present your bank statements and pay slips and then do your deductions and show that this is why she cannot afford it. And then she can apply. Once they accept that she's been here for 20 years, they will give her 2.5 years. Yes, you can apply for the fee waiver. Sorry, for the no recourse to public funds to be lifted, so that will enable her to claim benefits. At her age, typically she will be entitled to free public transport. She might be able to get some benefits, not contributory based benefits, but some benefits. And she's not likely to get pension because I'm not sure whether she's worked here and she's earned the necessary stamps. Yeah.
Okay, right. Thank you, Uncle Ben. Let's move to, I think Kevin has brought in one here, and it says that a friend of mine is on 5 years through his European wife. He gets more salary than his wife without any dependence or bank transactions between him and the wife. Would there be any problem when he's going for his settlement status?
Oh, no, because these days the requirement for exercise of treaty rights doesn't exist anymore. All you have to show is that their partner has been in the UK as well for 5 years. These days they will use your work record to determine your residence. So really, income doesn't come in at all. All they need to do is to put in their NI number for your wife and yourself, and it will tell them whether you've both been here for 5 years, and you will get your indefinite if she already has her indefinite and you've been here for 5 years.
Well, a bit of something on the periphery. Is there any summer barbecue coming up?
We're looking to organize a Christmas dinner dance for our clients, so celebrating our clients. We're looking to have that in December, so that's likely to happen. No barbecue. Look at the weather. It's raining.
It's raining. There's no sunshine for us to have a barbecue as it is now. So watch out for December. Obviously, you know BWF solicitors at the end of the year, there is the appreciation we show to our clients. So definitely it will happen. And maybe this year it will be something quite different and it will be a big surprise. So watch this space and keep your fingers crossed. This one says that I am a Ghanaian. My British wife, who is a Ghanaian descent, came to marry me and brought me to the UK. Now I have got a British citizenship. Marriage is broken down and I have to apply for divorce 4 months now, but no decision yet. I went to Ghana February, met a new lady, want to marry and bring her to the UK. Is it possible to contact the family in Ghana to go to Ghana court and apply for divorce for me because the marriage was made or done in Ghana? Or do I need to go to Ghana myself and apply for it through though the UK divorce is pending? Will Home Office accept divorce made in Ghana court so I can marry my new woman?
Well, if the divorce has been there for 4 months, it means that the divorce is under the new style, which is a no-fault divorce. It normally takes 6 months, so you've only got 2 months to wait. Um, if you've got uh, a court case here, I don't advise that you repeat that in any other jurisdiction unless it's essential for legal purposes. But for convenience sake, I'll say just wait. 2 months more will not take away your beautiful potential bride that you'll be marrying. Yes.
The earlier the better. Nippon Compentem.
Yes.
Richard Asante says that what does it mean when Home Office sends you an appeal, sends you a letter that your appeal sends in your refusal letter? I don't quite get it. What does
What does
it
it
mean
mean when the
when
Home
Home
Office
Office sends you an appeal refusal letter?
Okay, so it means that you've made an application, and unfortunately, the application was not successful, and the decision attracts an appeal instead of an administrative administrative review, and therefore you have to appeal. If you are in country, it's 14 days. If you're outside the UK, it's 28 days from decision.
All right. I'm expecting a baby this year. My wife is in Ghana, and I was in Ghana 6 months ago. I hold 2.5 years card. Can I apply for the baby when my wife delivers?
Well, if you're capable of looking after the baby, then of course you can. But then there will be issue of sole responsibility. The sole responsibility is a phrase that is defined as you taking the majority of the major decisions in the child's life. Now, a man and a woman with a new baby, who is likely to take the major decisions in the child's life? Even breastfeeding alone is is a major decision for a baby. So yes, I mean technically yes, but the um, you're going to have issues really. How are you going to feed a baby? It's just a baby. I think you should wait. If you want to spend more time with a baby, of course you can invite them on a visit, and then when they come, they can stay for 6 months at a time, and then go back. When you've got your settlement, you can apply for the wife to come. Yes.
Okay. Let's pick this one. Says, my name is Joyce. I have a baby who has a settled status based on her father. I am an overstayer. Can I apply to regularize my status relying on my child? And if yes, what will I be granted when I do that?
Well, your child has got indefinite leave. That's a settled status, and under Appendix EX1, you can apply for parent of a child if the child is British, has indefinite leave, or has lived in the UK for 7 years. Even if the child has got limited leave, those coming from outside can rely on that, but you can't. But you can use, Article 8 and Section 55, welfare of the child principle. If you're a woman and it's your child, a child is more likely to need you than the father, and therefore that's a better case to make. But he's got settlement, so you are likely to get, 2.5 years as a parent.
Okay. 0739920846. Remember, we're live on BWTV. Uncle Ben, our resource person, is the senior partner of BWF Solicitors, our trusted partners when it comes to the law. We have several means of getting the community education going on. On Thursdays between 9:30 and 11 o'clock in the morning, between 9 and 10 in the morning, we're live on Rainbow Radio International and also on BWTV. Now, Friday between 9:30 and 11, Remember, Thursday is 9 and 10 in the morning. Friday, 9:30 in the morning and 11 a.m. Then Saturday afternoon between 4 and 6 p.m. British summertime, we have the community and the law, which we are doing right now. So you can join us and enjoy the program, the discussion, enrich your knowledge, and of course, be so emboldened to be able to face the law when it is that you find yourself in that situation. BWF Solicitors is our trusted partners. Definitely call them on 0208 493 7340. There are a few questions here. We've dealt with the one for Joyce. Let's see this one. And this one is asking, what does it mean, anonymity direction not made? Sorry.
Case. Okay, so when you appeal in immigration cases, you can ask for anonymity. Anonymity, as it stands for, is to anonymize, which means that they make you blank. So your name, instead of Bernard Owusu or Bernard Owusu, will be BNO, so that when somebody sees BNO, they don't know it's me. It's just to protect your privacy. And in family cases where the children are involved, the full title of the case is not reported. And where they make decisions about children cases in court, you will always see cases with ZXY versus BWY, AAB versus CWD. It's to anonymize the title of the children and their names. But in immigration cases, all the decisions are published. Every single decision is published. So if somebody doesn't want anyone to access the information, they can put in a request to the judge for an anonymity order. And where the judge starts the case, he mentions your name, he says no anonymity order made, which means that the case can be published with a full title, including your name and everything.
Okay. This one from Kevin says that, can you go over your update yesterday about the 2-year extension of the pre-settled holders from September and their settled status automatically, and the children born to EU nationals being British straight ahead, born between 79 and 2020? Does it include their stepchildren as well? Uncle Ben.
Okay. Well, so first of all, the law about EU extension has been amended by APP EU 1 and 2. Both EU 11 and EU 4 have been amended. The Secretary of State has been given power under Section 3 of the British Immigration Act, and they've created an exemption. What they said is that for certain people, because of the decision in the case of the Brexit monitoring group that took the British government to court, and a determination was made that their decision requiring people to apply for indefinite leave to remain at the end of their 5-year residence is unlawful, because they don't have to apply. And the fact that they don't apply, they do not become illegal. So the British government said, you know what? From this September, we are actively going to go through our system. There are people that we will give freely 2 years extension on their pre-settled status, limited leave to remain. So they haven't given the criteria, but I suspect that they will estimate that those whose leave are coming to the end. Bear in mind that Brexit started, we started applying for the pre-settled status, I think in 2018. So some people are coming to the end this year. So instead of waiting for the 5 years to end, they will give you extension for 2 years. It may be that it will cover almost everyone. I'm not too sure. But they said they will actively go through their system and extend people's pre-settled status by 2 years. They also said, and this is the British government being smart. I mean, they've lost the case, so they're doing what they shouldn't do. And they said there are also certain category of people who are on pre-settled status, and they will actively search their system and they will give you indefinite leave to remain or settled status. Again, the criteria will be those people that they can find have been here for 5 years, and they will be using your NI numbers. My advice is that if you haven't put yourself in the system and you are an EU national, EU family members, non-EU family members, so person of Ghanaian descent or some other descent who is married or a child of an EU national, then please put yourself in the system so that when they are actively distributing the confetti, you will be lucky and they will give some to you. Because we have situations where, like somebody said, they've fallen out with their EU sponsor. Their leave is coming to an end. If they dash you another 2 years, it's possible it could take your time to 10 years lawful residence. It's possible.
It's possible, yeah.
So that's why I'm saying put yourself in the system. And if they give the confetti, you might get some. I did say that children born between 1983 and 2000 to EU nationals are automatically British citizens. Before they had to apply or they had to naturalize. They've gone back to amend Section 50B of the British Nationality Act, which in effect amends Section 1 of the British Nationality Act, which means that if somebody was born here to an EU national, so stepchildren are not born to the EU national. Stepchildren are non-biological, somebody would say acquired children. So they don't form part of this. It's biological children of EU nationals. And we all know that under our law, if you're married to a person and you give birth, the father of the child is the husband of the woman. And therefore, even if they are not biological children, but they are children of the marriage, then the child will also qualify. The reason why I brought that in, that most of these people will be over 23 years now, over. But they've got children. So if they are British, then their child is a British citizen, otherwise British citizen by descent. And if they've got children outside the UK, then their children are also British citizens, otherwise than by descent. And it's very important. I think I may have to have a program about explaining the different types of British nationality. There's a case I'm doing, and I think I'm very confident I'm going to win that case because the Home Office is not aware of what is coming to hit them, which is basically that this woman who was born in Ghana to a British father and a Ghanaian mother, she then traveled to a European country. She acquired a European passport. She came to the UK. She acquired a British passport. She went to marry a Ghanaian national. She applied for a visa for the Ghanaian. They refused her because they said, yes, you hold the European passport, but you were a British national first, which means that you are not exercising a treaty right. And because of the case of McCartney, you couldn't transfer your residency to your husband. You have to bring him under the immigration rules. We made an application. It was successful. He came here. But then when he reapplied after 6 months for the limited leave to remain, they refused that again using the McCartney principle that she was born British. She was born in Ghana. Now, my understanding is that any person who was born prior to 2006, whose parents were not married, is not automatic British citizen. So this woman is not British citizen. The country to which that she holds a European passport also bars dual nationality, although there's a dispute as to whether a person who holds European nationality could be barred from holding another European nationality. It's a bit complex, and I will try and see whether we can deal with those things, because there are people in Ghana now who may be British citizens because of the change in law of the British Nationality Act.
Well, I would be very, very interested in that. So, viewers, keep your fingers crossed, watch this space. That explanation would definitely be coming as a full program on at least the community and the law. It will be live on BWTV. The very final one before we go to our quiz segment, and when this one says, if your appeal is allowed, what next?
If appeal is allowed, Home Office has time to appeal, 14 or 28 days. If they don't appeal, then it leads to implementation. Implementation could take months. And that's it, really. So once your appeal is allowed and they don't appeal against the allowed appeal, it means it's binding on the Home Office. the binding effect of immigration appeals. There's a case law on it. So the Home Office cannot dispute that. They cannot come back and say, oh, Massa, we don't like your face, so although you won the appeal, we're not allowing you to come. That's not possible. But it's the implementation that takes a while. And that's why people will have to wait for the implementation to happen.
Well, we have been discussing for better or worse, but not my asset, the division of assets or the distribution of assets when divorce is granted and the marriage is broken down. Gwen is taking us through that. We have a few minutes ahead of us to finish the program. We're going to take another break, and when we come back, we'll be looking at a question I will pose. Now, remember this, when I spoke with Uncle Ben earlier on in the program, the Supreme Court has recently decided that financial relief or settlement applications end automatically if one party dies during the legal process. The court decided that the rights to apply for financial relief are personal rights and obligations that can only be adjudicated between living parties. Anger and another in substitution for Hassan appellants versus Al Hassan deceased and another respondents in 2023 UK Supreme Court case 2022. We'll be right back, and I have this passionate appeal I would want to make. Think about when you have left this life. What do you leave your children and your dependents with? Think about that and speak to BWF solicitors. We'll be right back.
Our private client services team is recognized for providing clear and practical legal advice to our clients in the United Kingdom and Ghana. Expert help with will writing, probate or estate administration. Our will writers and probate lawyers can act for you to obtain grant of probate and carry out estate administration on your behalf. The probate takes place after someone dies. If there's a will, the named executor is responsible for ensuring that the estate of the deceased is secured, assessing its value and paying any inheritance tax. If there is no will, the interstate and inheritance rules require similar responsibilities. Our lawyers offer strategic and practical solutions to the issues which clients face, whether it's in relation to succession planning, will preparation, probate and the administration of estates, immigration and visas, contentious family or probate disputes, administering estates often with inheritance cross-border issues, international trust advice including residence, domicile issues, wealth preservation, a fast, efficient service from SRA-regulated professionals, transparent pricing. BWF solicitors, let us take care of probate.
Well, somebody has just sent a very interesting text message to my phone. It says, I mean, some women walk away 50-50 or no 50-50. Life goes on. I mean, that's a very profound something.
Yeah, quite cool. I have encountered many women who have walked away and said, lawyer, I don't want anything from him. I came into the marriage with my conscience intact. I leave with my conscience and my reputation intact. So, but just so that everybody knows, it's obviously an issue live in the church, in the community. Ghanaians are by nature very conservative people. We are supposed to be very religious people. I'm not sure whether religiosity is what determines this. But yes, Kweku, it's very true.
Well, if it doesn't work for you, walk away. In full, but not in pieces. Or walk away in peace, not in pieces. Well, let's go to where we'll have our quiz segment, and I have a question for you. I'll see how many of you would have an answer to that, but then I'll get Uncle Ben to help us. Brahma Isifu and Mariama Isifu married in Ghana under the ordinance in 2003. They came to the UK in 2005. Well, in the UK, they both worked as chartered accountants in the city of London. They went back to Ghana to set up an accounting firm, which became very successful. Unfortunately, their marriage broke down because Mariama was alleged to have cheated with another man. Soon after the divorce, Mariama moved to the UK and filed for financial settlement at the High Court for a share of their £3 million asset, which was solely in the husband's name. 2 months before the final hearing, Brahma had a fatal accident. Brahma's children from his previous relationship challenged Mariama's application for financial relief because he was dead. Okay. What is likely to be the court's decision? 1, they will give half of the matrimonial assets to Mariama because she was previously married to Brahma. 2, Mariama's application for financial relief cannot proceed because Brahma is dead or is deceased. Or 3, the court will dismiss the children's application because Brahma is deceased. Now look at this scenario again. Brahma Isifu, Mariama Isifu married in Ghana under the ordinance in 2003. They relocated to the UK in 2005. Whilst in the UK, they both worked as chartered accountants in the city of London. They both went back to Ghana to set up an accounting firm. It was very successful. Unfortunately, the marriage broke down because Mariama was alleged to have cheated with another man. Soon after the divorce, Mariama moved back to the UK and filed for financial settlement at the High Court for a share of their £3 million assets, which were solely in the husband's name. 2 months before the final hearing, Brahma unfortunately had a fatal accident. His children from previous relationship challenged Mariama's application for financial relief because Brahma was dead. What is likely to be the court's decision? Okay, let's see what answers you bring. Is it 1, where they will give half of the matrimonial assets to Mariama because she was previously married to Brahma? Is it 2, Mariama's application for financial relief cannot proceed because the man is dead? Or 3, the court will dismiss the children's application because Brahma is deceased. When it comes to people dying and talking about deaths, it gets to me. So I have kind of mellowed a bit. But well, let's see what it is because we are learning now. So let's see what answers you bring. I have a few minutes to get to that. So Dongote Dongoye says that is number 1. Number 1 says they will give half of the matrimonial assets to Mariama because she was previously married to the man. Okay, Edward, thank you for that. Let's see what others will also bring. You can send it to the text number 0739920848 or 0795042278. Rebecca Amoako says that is number 1. So says Edward Dongote, who also says it's number 1. Who else is coming? Yabua Kennedy says it's number 1. Okay, number 1 seems to be very popular. We'll see what lawyer will give us. Who else? Okay, for the sake of time, let me go to Uncle Ben and find out what the verdict is. Uncle Ben.
Well, Kweku, if you put the nuggets there. The nugget is the answer to the question. Let's see what the nugget says.
Let's see what the nugget says. Okay. The Supreme Court, okay, let me read it. The Supreme Court has recently decided that financial relief or settlement applications end automatically if one party dies during the legal process. The court decided that the rights to apply for financial relief are personal rights and obligations that can only be adjudicated between living parties. Uncle Ben.
So let's go back to the question.
Okay, so let's go back to the question. And good. This one says,
So what's happened?
Brahma is
One
dead.
person is dead. This is a financial settlement.
Mhm.
Same case as Onga. This is two parties started.
Mhm.
Before final hearing, one party dies. What did the Supreme Court say? For financial settlement applications, it's between two living persons. If one person passes away, then the case ends. So let's go to the question and look at the answers.
One,
The answer
they will give
is
half to the lady because they were previously married.
no,
Two says Marema's application for financial relief cannot proceed because the man is dead.
and that's the
three,
answer.
oh, okay. I don't need to even go further.
No, 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 no. So the answer is two. I mean, I know that the fairness dictates that, what Edward Dongoyo and others have said. But as we know, the answer is two. The case of Onga and another, the right to apply for financial relief are personal rights and obligations that can only be adjudicated between living parties. Brahma was dead, so her case stops. That doesn't mean that she cannot proceed to bring an action under the Inheritance Act or in Ghana, even under the Wills Act. For support, she can. But for this particular case, it will end, and that will be the end of the matter. Thank you.
So with that, we say that take particular notes. Sometimes there's some technicalities in the question and the nuggets that we bring. Take particular note of that. Tradition we can't overlook, so I'm going over to Uncle Ben for him to do a quick summary of what we discussed now before I draw the curtains down on the program. Uncle Ben.
So, Kweku, I mean, unfortunately, although we all desire that our relationships, loving relationships, stay permanent until God calls us, unfortunately, it doesn't work like that. I always advise my clients to prepare for the worst in every situation, because then what you do is that you've got a shock absorber. If it happens, you've got a shock absorber. People have looked at prenups or prenuptial agreements. For most of us in the community, it's not something that I would recommend because really, how much do we have? And the courts will throw that away if it's a needs-based case. So ideally, if you have issues and you're divorcing, please try and settle it between the two of you. Settle before you go to court, because judges prefer that settlements come by the parties. I have seen cases where one person, clearly has become very unwell because of the poor decision. There's a case that I dealt with. The man was 83, the wife was 45. The only thing the man got for his 50 years of residence in England and the wife's 15 years residence in England is a hut in Uganda. The woman got 2.5 million pounds because they had 3 young children. So we all have to prepare. The men, the advice I give you, even in Ghana, is that don't say, I got this. The woman also stayed at home. I mean, I'm looking at a situation where somebody I know, it takes a lot of time off. She can potentially earn about 100 to 200,000 pounds a year. She's earning about half of that. And she's doing that because of her children. Meanwhile, the man goes to work same time every day, every week. He hasn't stopped because of the children. So when it comes to breakup, you don't say to her, oh, that I have acquired this, so you don't get anything. Well, remember that making a home, and she is a professional, and with the work that she does, she potentially can earn between 100 and 200,000 pounds, but she's earning half of that. So these are the things that I use to advise the young people. I always use myself as an example. Everything I acquire in the joint names of my wife and myself. There's no dispute. My family knows that. So one day when I'm not there, they don't come and cause trouble. Having said that, you must always draw up your will, because once the will is in place, no family can come and cause trouble. That is where I leave all of you. And we hope to see you next week. Have a good weekend. And please try and rest, because rest is very important for almost all of us. The young man who was coming from Ghana to join his wife here on a skilled worker route, he fell and died at Heathrow Airport. I've seen the video today. It's really, really heartbreaking. Please rest. The work is there, but also rest. If you've earned something that will keep you, pay your bills and a little to put away or send to family in Ghana, please rest. Okay, let us rest. Rest is very important. Kweku, thank you very much.
Thank you very much, Uncle Ben. And with that, we draw the curtains now on the program for today. And we discussed how assets are distributed according to the laws of England and Ghana. Uncle Ben, our senior partner, was our resource person. Thank you so very much for your time, your help, and everything. And also thank you to BWF Solicitors for your kind sponsorship and push for us to come on this program, The Community and the Law. On behalf of the production team, Professor Ade, Sheila Ankra, Patmo Doku, Cynthia Brown, Lawyer Charles Asma, and all the wonderful people from BWF Solicitors, I say be good, and we'll meet again same time next week. And until then, please rest, as Uncle Ben would say. Good evening.
Our private client services team is recognized for providing clear and practical legal advice to our clients in the United Kingdom and Ghana. Expert help with will writing, probate or estate administration. Our will writers and probate lawyers can act for you to obtain grant of probate and carry out estate administration on your behalf. The probate takes place after someone dies. If there's a will, the named executor is responsible for ensuring that the estate of the deceased is secured, assessing its value and paying any inheritance tax. If there is no will, the interstate and inheritance rules require similar responsibilities. Our lawyers offer strategic and practical solutions to the issues which clients face, whether it's in relation to succession planning, will preparation, probate and the administration of estates, immigration and visas, contentious family or probate disputes, administering estates often with inheritance cross-border issues, international trust advice including residence, domicile issues, wealth preservation, a fast, efficient service from SRA-regulated professionals, transparent pricing. BWF Solicitors, let us take care of probate.